Hi, this is Curt and welcome to another edition of Fire Law. In this session, we're going to talk about something that I cover in my book. We talk about it in some of the classes. It's a difficult area. We're going to talk about the Fireman's Rule, or I think the better term, I get criticized when I use the term Fireman's Rule today, the Firefighters Rule. But we'll talk about that. But with me, I have a guest from the DC area. He's a practicing attorney out of the DC area. And before I introduce him, I just want to kind of give you an understanding of how specialized the law has become. And many of you know my son is a surgeon, and today, when you go to medical school, you don't just hang a shingle out. You go to medical school, you got to go through residency. If you want to become a surgeon, then you become a surgeon. And then some people want to go into orthopedic surgery. They want to go into trauma surgery, and some will go into burn surgery. Okay, and analogous to that is what happens today in law school, okay? And that we have folks that go to law school. Well, you can just hang your shingle out, but people become specialized, and some become trial attorneys. And then out of those trial attorneys, some become even more specialized, and they go into something as unique as burn litigation. And I'm really fortunate to have with us, and we are, to have with us. And Paul, I want to make sure I don't butcher your last name too bad, but Samakow, is that it, Paul Samakow?
That's close. Thank you. That's an A minus effort. It rhymes with the gas station Amoco with an S in front of it. Samakow.
Samakow. Okay, cool. But Paul is out of the DC area, and I kind of, Paul, you and I haven't talked about this. I kind of consider myself to be a generalist. Kind of like for the fire service, like a veterinarian. You might have a veterinarian that is a specialist in heart surgery or orthopedic surgery. My dog needed an orthopedic surgeon not that long ago. But you have, I'm kind of like a fire service, but I'm like the veterinarian who handles giraffes, and so I'm like a generalist, but for that particular type. And you're really, first of all, hats off, you're a trial attorney, but the other side of it is handling burn litigation. But first of all, welcome.
Thank you.
Welcome. And how long have you been an attorney?
I have passed my 40-year anniversary last October, so
wow.
40 plus.
Yeah. Wow. That's you've seen a lot of change. Me too. Yeah. I'm just closing in. I'm 36 years, so it's but tell us, we were going to talk about the Fireman's Rule, but before we get to that, let's talk about burn litigation and some of the things that you see from your perspective.
Well, it's at the same time, it's extraordinarily personally satisfying, and perhaps one of the most difficult types of litigation that there is because of the subject matter. What I think any doctor that involves him or herself with treating a burn survivor will tell you is that burn injuries are, without question, the number one most difficult to treat, and clearly among the most painful injuries known to medical science. And of course, the reason for this is that a burn injury can adversely affect any part of your body, multiple parts of your body, multiple functions, multiple systems of your body. I mean, what can happen as a result of fire or scalding water or radiation or chemical is yet to be fully understood by doctors the world over. And so you have Joe or Sally who presents with burn injuries, and it's really an exploratory process for them to get to the problem and then to try and resolve the problem. And so then on the flip side, when you come into the legal arena, as I'm sure you can appreciate, Curt, a case is about what you can prove. And if you can't prove it, you don't even get to the jury to make the claim. In other words, just buying the ticket to the movie theater in our analogy, doesn't allow you to sit down. You can only sit down when you pass the test. And in the legal arena, you have to have certain criteria, and every state is different, and every federal jurisdiction, right? You have criteria that you have to get over the hurdle to be allowed to present evidence. And primarily this involves the use of expert witnesses. An expert has to be able to testify beyond reasonable certainty, with a reasonable degree of medical certainty is the standard that is used in most courts in the United States, regardless of jurisdiction. Reasonable degree of medical certainty. That doctor has to raise his or her hand and say that what they're getting ready to say, their opinion rises to that level. And if they can't say that, their opinion isn't allowed. And if their opinion isn't allowed, then the issue, the claim, the concern cannot be used to further the case of the burn survivor. It will not be allowed to be considered by a judge or a jury to compensate that burn survivor. So, and I'm not trying to be long-winded here, but I mean, it's a great question you asked. When you start then at that premise that that expert witness has to testify in this matter about his or her opinion, if the injury itself is that problematic and that difficult to treat, the doctor may only be able to say, I think, or I believe, and that standard isn't good enough. So that's why, from the medical side, it's very, very difficult often for some injuries, and it's potentially even more difficult on the legal side, because again, you have that bottom line. If you can't prove it, you can't claim it.
Yeah, we get the damages part of it. You also have the causation part, and it just seems like
Right.
causation. And you think about from firefighters' perspective, we've got a host of possible causes when a firefighter gets burned, starting with, should the firefighter have been in there? Did they stay in there too long? And those types of things. Did their PPE, our personal protective equipment, do what it's supposed to do? And so you've got proving damages, which I get it. But then proving causation. Is most of your litigation more civilians, or is it firefighters, or crossover?
It's a mix, but it's more civilians.
More civilians. And
yeah.
So in terms of causation, so you have, I'm assuming you have well, you tell me, I don't want to assume. Where do what's a common fact pattern that you see?
With, in the civilian sector, interestingly enough, more women are victims or suffer burn injuries than men. We like to think of men as being the daredevils, but interestingly enough, they come from the home, and it's women, and more often than not, it comes from the kitchen. People are just not careful in the kitchen. And then there's a large segment, unfortunately, which is so preventable, of children who have scalding hot water burns or other types of contact burns from pots and pans that may be hanging over the ledge on an oven, and they reached up, and next thing you know, their whole body is burned with hot water, or they put their hand on something and they shouldn't have because the parents aren't taking the precautionary measures and not watching their children. So that's a large number of them. For a firefighter, again, and we'll get into the Firefighters Rule, but there's only 18 states in the United States that allow for those claims to go forward without further discussion and further investigation and further analysis. And even if you're one of the majority of states that has this Firefighters Rule that theoretically prevents a firefighter from making a claim against a homeowner whose house is on fire, that he ran in and tried to, save the cat or save the child upstairs, or, putting out the flames, what have you. those are difficult cases,
Mhm.
but they can be overcome in many instances, and sometimes, unfortunately, not. And then you have a smaller number of cases where there's third party, meaning not the homeowner, but like a repair facility that didn't do a job properly, where something exploded that should not have, and then you want to go after the company that did the repairs negligently. So the potential for the fact pattern is as wide and as far as your imagination.
I know with one of the things that jumps, I think, immediately to firefighters' mind is, and I know firefighters that have given their spouses the contact information for an attorney, and they tell them, if something ever happens to me, this is who I want you to go talk to.
Right.
But the one of the challenges with suing your employer is workers' compensation exclusivity, which,
Right.
and so it makes it, the exclusivity is you're not permitted, you basically get workers' compensation benefits, and the trade-off for getting workers' compensation benefits is you're not allowed to sue the employer. So it's hard, it's not impossible, but it's hard to sue the employer. But you can go after, and I use the term Mrs. Smith, who Mrs. Smith is the one that did something negligently and started a fire in her house, and now we go to Mrs. Smith's house, and then somebody gets hurt, and that's where Paul comes in. Now, walk me through putting the case together.
Well, okay, so I want to talk about one of the 18 states that does not have this prohibition. And Curt, maybe now would be a good time just to, and please chime in if you have a better understanding than I do. But the Firefighters Rule basically says that, someone in the line of duty, a fireman, a policeman, an emergency responder, who suffers an injury in their line of duty is prohibited from making a claim against the party whose negligence caused them to be there in the first place. So take an example, you use Mrs. Smith, that's a fine, that lady, boy, she's got a lot of cases against her, doesn't she?
She does.
All right, so if Mrs. Smith isn't paying attention when she should be, and the candle that she put on the side of her bed escalates, and on her night table next to her bed, and that the flame escalates and it causes the mattress to go on fire, which causes the shade, the whole room then is on fire, and it just continues to spread through the house. She's clearly negligent. Well, in one of those firefighter rule states, Joe the fireman cannot go in and sue Mrs. Smith for her negligence for the injuries that he may suffer. But the fact patterns that allow for it, which are the strongest, is when you don't even have to involve yourself with Mrs. Smith. And I'm going to quote from a very scholarly individual whose works I have recently read. The guy's name is Curt.
Uh-oh.
He published this several books where he gave an example of the Acme Stairs repair company, where 3 days before the fire in Mrs. Smith's house, the Acme Repair Stairs Company came in to repair the stairs between the first level and the second level. And they used the wrong nails. And when the fireman with his gear and what have you goes up those stairs to get little Junior out of fire's harm's way, the stairs collapse and he falls and breaks his leg. Well, because the negligence of the fire in the first place caused him to be there, he can't sue Mrs. Smith in one of those firefighter rule states. But he can sue the Acme company for the negligent repair of the stairs because they used the wrong nails and they didn't secure the boards properly. So his injuries could be claimed against the Acme company, both for his broken leg and for the fire injuries that he suffered because he wasn't able to get up and walk away or run away from the fire that ensued and burned him. So again, I mean, we could just go on and on and on with all the different potential for injuries, but it is one that, in my mind's eye, Curt, I don't see that there's ever a situation where there's any type of serious injury where a firefighter should not at least contact an attorney and have an investigation done. The worst thing that can happen is, okay, they fall back on the workers' compensation benefits. But workers' compensation benefits, yes, you're right, 99.5% of the time, it is an exclusive remedy. You can't sue your employer. You're not suing the city of or the fire department of. The claim is just simply it's there and you have those benefits, but they are very, very rarely adequate to completely cover the money needed for the physical injuries and the psychological injuries of suffering burns. So you want to look at a potential source of what we call a third-party claim, a claim against someone else that may be responsible for what happened to you if you suffer an injury in the line of duty. Yeah. The money typically is unlimited, as it should be. The more severe the potential injury. And it would be just, in my mind, absolutely foolish not to at least pick up the phone, give all the facts, and let an experienced attorney investigate those facts and then give you a, hey, I think we got something here, let's pursue it, or gee, I'm sorry, all the roads to Rome are closed today, and and you're stuck with workers' comp.
Yeah, that's, I had never really, I know I do recall writing that, back in the day when I put the book together, but you're absolutely right. Now you got my wheels turning. I've done a little bit of a study into the Beverly Hills Supper Club fire, as well as, we had the Station nightclub fire here in Rhode Island, and they had some very sophisticated mass tort attorneys jump in on those, and they were holding people liable that I think I'm a pretty creative person, but I can't. They added for the Station nightclub fire. They added like Shell Oil Company to the list of defendants, because the band, Great White, certainly the band was sued, but they sold tickets at a Shell station, and there was a poster up if you wanted to buy tickets at the Shell station, and I almost feel like I need to go take a shower after even saying this, but basically they were able to bring Shell to the table, and they coughed up some money. And I remember listening to a lecture by one of the attorneys, and they find, I think it was Rubbermaid, or one of those plastics manufacturers had provided some of the waste baskets and different things, and they said that the smoke, everything that burned in the room contributed to the smoke, and therefore if you sold a rubber waste basket and it went into smoke, it potentially contributed to the deaths of the people. So it was, I think it was a stretch, but I had never really thought about that, even for a firefighter. And we're not talking about a sprained ankle or a back injury. We're talking about something that is a life-altering type of burn injury where, there's been a lot of them. There will continue to be a lot of them, unfortunately. But
indeed, yeah. I mean, that's again I think I probably am inclined to lean in the direction you just suggested about being a stretch, but on the devil's advocate side of it, if there is a potential defendant that might bear some responsibility, you want to think, and more often than not, it is correct that the legal process will weed them out if in fact they don't have responsibility. And if they do, then they should be contributing to the loss.
Yeah, I think the Beverly Hills Supper Club fire, there's quite a bit written on that, and there was several hundred defendants brought into it, and there's actually a strategy that the plaintiffs' attorneys were using, and it was pretty successful. And they they got some money for the victims. There's burn victims, there was inhalation victims, there's certainly fatalities and so on. They
Right.
employed the same thing. Yeah. Well, tell us a little bit more about your practice. Are you a solo practitioner? Are you in a firm or?
Well, I reached the grand old Medicare age of 65 back this past January, and I think I might have been 62. I finally decided to hire another attorney. I am a sole practice attorney, Washington area, Virginia, Maryland. And I had a pretty robust, big practice representing people for all measure of injury type claims. And I guess it was about 3 years ago, I hired an attorney to assist me with the litigation practice that I have in Virginia. He's licensed only in Virginia. And it opened up a lot of time for me to do other types of things. And literally today is the first day I now have a second attorney on board who's licensed in Maryland, and he'll do a lot of my Maryland litigation. And the plan was really just to allow me to take more time and devote more energy to the bigger end cases that I have, many of which are representing burn injury survivors. So it's a 40-year practice where 37 and a half years was just me, and I had 17 people working for me, and because of COVID, I now have 15. But then I brought in this attorney, so it's 16. But I have a big, robust plaintiff's injury practice that includes, a number of cases nationwide representing burn survivors, West Virginia, Arizona, Georgia. I could just keep going on, but those are a couple that pop to mind. Those are a couple of the bigger ones.
Yeah, I mean, I don't think people understand not only the specialization, but the expertise that goes into being able to competently present a case and then overcome all of the defenses. Like insurance defense attorneys are very good at getting cases knocked out or making arguments, dragging it out, and really making it difficult for plaintiffs' attorneys. And it just being a trial attorney has become such a specialty. And then when you get into a niche like that, I think it's worth, and that's really why I wanted to have you on, so we could have this conversation. And then if folks out there, because of the risk that all firefighters are under when it comes to these types of injuries, certainly they can reach out. Now, so if someone was in, let's say I was up in Anchorage, Alaska a couple of years ago. So if somebody in Anchorage, how would you be able to represent someone in Anchorage?
Well, the first thing that happens is I do as much of an investigation as I possibly can, from behind my desk. It certainly then is appropriate and something that I do. I hop on an airplane and go to where my client is, because you never, ever, ever can have enough information as a lawyer. I like to tell people who are willing to listen, I think one of my strengths, I'll call even my superpower, is that I know how to listen and I know how to observe. And sitting in your home, I can get more information in 15, 20 minutes than I could with you on the phone for 3 hours. But I'll do an investigation and I'll make an independent decision that I can or I cannot help you if you have, been a survivor, a victim, you've suffered a problem, a burn injury. And that part of that investigation might be consulting with expert witnesses. So, I often have, fire investigators who I pick up the phone and call. I have mechanical engineers. I have all measure of consultants who, I can take 10, 20 minutes and explain the basics of the case and say, what do you think, Fred? And they'll say, well, you need to find this out, you need to find that out, and I make a few more phone calls. But ultimately, if I decide based on all the information that I have now that there is a claim and I can do something and help this person, the next thing I do is I go and I find the best attorney I can find in that state, and I ask them if they would like to enter into a co-counseling relationship with me, because my license to practice is limited to Virginia and Maryland. but I have practiced law in many, many states over the years by getting another attorney to work with me as what we call co-counsel. And then we make a motion in front of the state's Supreme Court or highest court to allow me to practice law in that state. It's like a one-time deal where you go in and the judge looks you up and down and says, well, I think you'll be okay. Just make sure you follow our rules, and it's a rubber stamp process for the most part. But, I would never pretend to go into a state and expect that I'd know all the ins and outs of their laws and their procedures. So I do bring in experienced counsel to assist me. And this is always, what I call the 2-for-1 deal. The client signs an agreement with me, but then I bring in another attorney and they're not paying more. So I get, the best of the best in whatever state that I might be in to work with me. And then between the attorneys, we have a division of labor that I'm going to do this and this, and he's going to do this and that. And eventually, after all the efforts of those defense lawyers and the insurance companies to kick us out or to knock us down, most of the time, these cases resolve before we actually have to go into a courtroom and have a trial. Mm-hmm. But as an attorney, I learned early on, you never, ever assume that you're going to resolve the case or settle the case. You are always full steam ahead as if you're going to go into the courtroom and let a judge or a jury decide the outcome. So we're always preparing. As an attorney, Curt, you're familiar with all the process of discovery. We have depositions, we have written questions called interrogatories, we have medical examinations where the client has to go to the other side's doctor and submit to an exam. There's all measure of things that go on before we ever get to the possibility of resolving the case out of court. But these are big cases. They garner sometimes millions and tens of millions of dollars. Again, depending upon the severity of the injury, whether or not the individual can continue on with their occupation, if they can ever get back on that fire truck. There's any number of things that have to be considered in putting together what we call the damages. We talked about that a little earlier. First, there's the hurdle of causation. Did this cause the problem? Well, okay, if we get past that, now what is the problem and what is the monetary value of the problem? Look, let's face it, you can never replace, what happened physically. I mean, nobody's going to raise their hand and say, burn 3/4 of my body and I'll need scar revisions for the rest of my life. Oh, okay, give me $12 million. That'll be fair. No one would ever do that. But at the end of the day, a jury has to make a decision on how much compensation to give the individual. And, our goal is to try and get them as much as humanly possible. So right. It's a long process. They take a while. The average case could be more than 2 years. A few of them, they do resolve quickly because it's so clear and because the injuries are not that bad. But the worse the injury, frankly, the more likely it is that it's a process. And it's a vexing one and a taxing one, not just, for the attorney handling all the legal, balls in the air and trying to do all those things, but for the client as well, because, there's an absolute degree of stress that comes from having a legal matter hanging over their head and wondering what the result is going to be.
Yeah, for sure. I think I might have kind of taken us off track a little bit because I think we wanted to talk a little bit more on the Firefighter Rule and some of the exceptions. I think because while the Firefighters Rule does stand as a barrier to recovery by firefighters, there's a number of exceptions. And again, not every state recognizes it. A lot of states have abolished it, but not every state recognizes it. But it's not a hard and fast rule in that there's always exceptions, and there's always the possibility that we can find a way to hold the responsible party actually responsible.
Absolutely.
Yeah. So.
Do you want to hand the mic to me and you just want to let me talk? You want to ask me questions?
Yeah, go for it. Go for it. That's, I honestly, I didn't prep for this, so I haven't really looked over my materials. And
Well, sure. What is that expression? I'm a lawyer, so I can just keep talking.
well,
You know.
we want to make sure people are still listening too, so we want to give them something, but absolutely
There you
go
All right,
for it.
well, stay to the end, and you too can learn the winning lottery number in your jurisdiction. But I'm only going to tell you at the end, and you'll be quizzed. Yes, Curt, that is correct. There are exceptions. So even though there are only 18 states that don't have the Firefighters Rule, all the rest of them, it isn't an absolute bar, no matter what. The first one that I hear frequently is that if the reason that the firefighter is on premises is because of something called willful, wanton, or intentional action, then that will get rid of the bar, the Firefighter Rule bar, to suing that person. Now, there's a catch-22 to that. More often than not, it is insurance companies that are paying these claims. So where you have something that is intentional, if I intentionally set a fire to my home and firefighter Joe goes in and gets badly burned, I'm not going to be able to make a claim that's going to go anywhere because insurance company policies exclude claims for intentional acts.
Mm-hmm.
Now, the other two words in that exception is willful and wanton. Willful, depending upon which jurisdiction you're in, can have a lot of different definitions. And that's one of the things I like about being a lawyer. A lawyer can take one word and describe what it means for the next half hour if he or she wants to. And then the lawyer on the other side will object to that, and they'll take a half hour and describe another meaning. But willful might mean that I didn't intend for my house to burn down. I just intended to set all these divorce papers from 4 years ago on fire because I don't want any memory of my painful divorce. And oops, oh my goodness, when I lit those divorce papers on fire, next thing you know, the fire jumped to the curtains and I'm trying to find Fido and we're running out of the house. So that might be a possibility. Wanton. Wanton also is another word that's used as a possible exception to that Firefighter Rule bar. Wanton. What is wanton? Anybody that's listening, could you please write me a little email memo on what wanton means? Maybe I'll use it in my next argument if and when the circumstances present that might be a possibility. I don't know what that means. Nobody knows. You know what it means? It's what judge decides on any given day based on his or her mood and maybe what they had for breakfast. Another exception that we see frequently is with preventing the Firefighters Rule from barring the claim is if someone knew or reasonably could have known or prevented further harm. So the fireman says, what's going on? Where are the people? And the individual says, it's upstairs and then downstairs. My cat is downstairs. But they knew that the stairs downstairs were filled with boxes, and they failed to tell the fireman, oh, watch out for the boxes on the stairs. Well, that's pretty lame. I mean, even in the best of situations, not in a stressful situation of, trying to fight a fire and get little kitty to safety, anybody could not, anybody could have a difficult time, descending those stairs. And so for the homeowner not to tell the firefighter that could be a basis to kick out that Firefighter's Rule, which otherwise would bar the claim. One of the big things that I've seen is where there are violations of county or state and local rules or ordinances and regulations. So if you've got, I don't know, let's just pick something, if you've got electric cords running and overloading a fire, not a fire, a wall socket, and it's very clear that that shouldn't be happening, and that's what caused the explosion, then we need to look at who it is that is responsible for that violation.
Yeah, Paul, I want to stop you right there, just because I want to point out to the folks that follow my blog, when you see a firefighter in New York City suing, and it happens very, very frequently that FDNY firefighters will sue the building owner. This is the law, because there's actually a statute in New York that allows firefighters to sue if their injury is associated with the violation of a city ordinance or city code. So very, very,
Right.
very, very common for FDNY firefighters. And I cover a lot of them in my blog. You see a lot of them in the news, but that's where this is the exception under the Firefighters Rule here in New York. Sorry.
Yeah. I mean, that's exactly. And that applies, I think, nationwide. And again, I mean, where the human mind goes and what it does allows for just an endless discussion of how those ordinances being violated can result in problems and then potential injuries. So again, it takes a thorough investigation with experts who can come back and say, yeah, this is what happened, and this should have never happened, and it wouldn't have happened if they were in compliance with the codes or the statutes or the requirements. And I mean, I don't think there's any one person's mind that's big enough that could talk about all the possibilities. I mean, they're endless.
Yeah.
But it needs to be investigated. That's the problem. I mean, everywhere I have been in what I'll call the burn community, we see that individuals who have suffered bad burn injuries probably never even think about the potential for compensation. And that's not a knock on them, because it's appropriate that they're thinking about getting well. Their physical injuries and their psychological and emotional injuries are devastating. I mean, the last thing that anybody's thinking about in those situations, or more often than not, the last thing is, oh, let's call a lawyer and see if there's some money in this for me. But when you get past the initial rush of medical treatment, maybe the caregivers are the ones who think of it. And then it's appropriate to at least get an attorney involved to investigate.
And, I know a lot of people that I talk to, and a lot of firefighters, they're relatively conservative in many respects, particularly when it comes to liability. And they tend not to support the kind of liability that we're talking about here. But all I would say to those folks is that there's costs associated with an injury like a burn injury. Just like somebody's a paraplegic or quadriplegic, there's costs. And the question becomes not what the costs are. The question becomes who's going to bear those costs. Because if someone's injured, then the costs are either going to be borne by the person's family, or they're going to be borne by society. They're going to go on the welfare rolls and so on. So it's not a question. The costs are going to be what the costs are going to be. The question becomes who is going to bear the responsibility for those costs. Is it going to fall on the person's family? Is it going to fall on really government to fill them? Or is there a possibility that some of the costs can be borne by people who bore some of the responsibility, not all of the responsibility, but some of the responsibility for getting the person in the situation that led to that? So I think that's an important point also.
Well, it is, and I, with all due respect, that there's one possibility that you didn't mention there, Curt, and that is that there just is nobody covering those costs.
Yeah.
I mean, let's look at cancer survivors that ultimately passed because they couldn't afford the medication or they couldn't afford the radiation treatments, and and hospitals aren't necessarily charities. and the government, you know, they don't qualify for government benefits, and they didn't have their own health insurance. So costs can be enormous, and a great deal of suffering can be found where they're not being adequately addressed.
Yeah. Well, Paul, thank you very much for this. And what I'm going to do is I'll provide your bio and your contact information, you know, with the posting. And really, thank you. I really appreciate the opportunity to have the discussion with you. And you'll be a great resource for folks that come to me, because I don't handle that kind of litigation. So certainly, you'll be getting a phone call from me, and we'll hook you up with local legal counsel, you know, to square away the you know, the ethical parts of practicing in different jurisdictions. But I really appreciate it, Paul. Okay.
Well,
Yeah.
thank you enormously. I'm gonna write this, and I'm gonna send it up to you to let you, you know, make your massaging and edits and changes, and you know, we'll talk. And again, I mean, you know, I just want to thank you for what you've done, Curt. I mean, I've gone through 2 of your books, and I mean, it was just, oh my God, an absolutely Herculean effort that you clearly extended to put those together. And I mean, that's just earth shattering. I mean, like I told you, I've authored 6 books, and the time that I put all of those together doesn't equal the one textbook that you did.
Well,
So,
I appreciate the positive feedback, and that's going to do it for another edition of Fire Law.
okay.